Good afternoon, AILA members. This is Mary Kramer and my good friend and colleague, Michael Vastine. Hi, Michael.
Hi, Ayla.
And we are reporting live from the AILA national offices. We came up from Miami on Sunday to hear back-to-back oral arguments in front of the Supreme Court. Yesterday, we heard oral argument in the case of Sessions versus Dimaya, very important case. And today, we heard oral argument in the case of Rodriguez v. Jennings, or Jennings v. Rodriguez, better said. So we're going to talk to you a little bit about what we saw as the highlights of the case, and then we're going to tell you how the justices are going to decide. Just kidding. We're not going to tell you that. But we are going to give you our takeaway from the oral argument. How does that sound, Michael?
Sounds perfect.
So let's lead off with crime of violence?
Crime of violence. Okay, so Mary, this is what you do. You wrote a book on it. What is the big issue with crime of violence, and why is this case at the Supreme Court?
So in Sessions v. Dimaya, and by the way, if the immigrant community, the bar, that's you, me, and everybody else, wins this case, it is going to abrogate the board's decision in matter of Francisco Alonso. So just to give you a little bit of orientation, that's where we are. The aggravated felony definition refers to 16A and 16B. This case involved a conviction in California for burglary, but the burglary statute has an extra element. It doesn't necessarily involve unlawful entry. So it wasn't going to be your regular aggravated felony, and it wasn't even going to be a burglary aggravated felony. The question was whether it fell under the definition of 18 U.S.C. section 16B, because the burglary statute in the ordinary case will probably lead to an act of violence occurring while committing the crime. So we're talking about a case where, if decided in favor of the immigrant, is going to sort of bounce out 18 U.S.C. section 16B, aggravated felony, potentially 237A2E, domestic violence, won't any longer trigger mandatory detention, and could affect criminal reentry for aggravated felony. So the consequences are big and will affect a lot of people.
Okay, so this couldn't be an aggravated felony for actual use of violence, but the Supreme Court had to take this issue up twice, once 2 years ago and then once yesterday, to talk about whether the offense had a risk of violence. So you mentioned matter of Francisco Alonso, and that had that case doesn't exist in a vacuum. But in that case, the court, the BIA had said that how do we know if there's a risk of violence? Well, we use this ordinary case test, and that test has a history in U.S. criminal law, which is why the Supreme Court had the case 2 years ago. So what was the case and the Supreme Court had last time, and how might that apply to the immigration context?
2 years ago, the Supreme Court heard a case called Johnson versus United States, a criminal case dealing with the definition of violent felony, which very closely patterns the language of 18 U.S.C. section 16B. And in that criminal law context, they found the ACCA, Armed Criminal Career Act, sentencing residual clause to be unconstitutionally void for vagueness. Why? Because nobody knew what the term violent felony meant. Nobody knows. Nobody's on notice, Michael, and understands what a crime that in the ordinary case will lead to the risk that violence may ensue. Who knows what that means? And that's what the justices were talking about yesterday.
Right, so in the old case, Justice Scalia wrote this scathing piece about you could poll some people, you could look around, and no one would ever agree on what is ordinary. So why don't they just apply that in our context now? Because they already said that no one knows what ordinary is. Francisco Alonso says we're going to use this ordinary test, so why don't they just borrow that?
Well, that's an interesting question. This concept of void for vagueness comes up in the criminal law context. It doesn't normally come up in the civil law context. So the question becomes, is immigration law close enough to criminal law such that we really need to take this concept and apply it in the immigration law context? And, counsel for the immigrant said during oral argument, in no area of two laws is there so much overlap as in criminal and immigration. And I have to say, Justice Kagan made some very interesting points. She talked about the fact that deportation leads to banishment. Deportation leads to detention. If that isn't bumping up against criminal contexts, well, then what is? But that's the underlying issue, whether this concept of void for vagueness, such that you get no notice of what's a violation of the law, should that criminal concept be applied in the immigration law context? There was also, I want to say quickly, Justice Gorsuch came out really strong and really, really good with his questions, and I was pleasantly surprised with Justice Gorsuch's contributions to the argument. And he talked a lot about the separation of powers.
Yeah, so that's interesting. So I guess his point was, if the statute was so vague that no one knew what it meant, well, maybe there's just a problem with the statute. And if there isn't some parameters put on the agency, well, why should the agency be making law? Because who's going to make this decision? The justices acknowledge this is going to be the 300 plus immigration judges trying to figure out what's ordinarily dangerous to them, or this statute comes up in the expedited removal context, in which DHS alone is alleging that an offense constitutes an aggravated felony. So that's not even passing through the Department of Justice's courts, and that just might be too much delegation of authority to the agency to make law. And so the justices seem to be pretty troubled by that.
Yeah, they feel very strongly that over 300 judges and frontline immigration officers, that's how they refer to them, should be making law and deciding what is a crime of violence. And then Justice Kagan jumped in and said, yeah, but that's what's happening. That's why we have a split in the circuits, and that's why we're at the Supreme Court. All in all, Michael, I felt really, really good about the argument. But now we got to talk about detention.
So we returned to the court today to see the case. Again, both of these cases are being argued for the second time. So the court couldn't resolve these cases after a single argument last term. And so this is in the context of prolonged detention. And so remember back in the early 2000s, the Supreme Court first said that indefinite detention after someone is ordered removed is unconstitutional. They can only remain detained for 6 months. That was the Vitus. And then 2 years later, the concept got back to the court. Well, a lot of people are detained for a really long time while they're fighting their case. And so this is the term that's applied here is prolonged detention. And so the respondents are fighting in front of the immigration judge while detained. They take their appeal, perhaps they get a remand, and the case goes on for months or years in many cases, as we know. And so this case today it presented a bunch of issues because there's a circuit split on how to look at prolonged detention and when constitutional rights may apply. And of course, the circuits have been reluctant to rule that the detention statutes are unconstitutional. And so the circuits that have answered this question had uniformly said there's got to be some limit on this detention. Just a matter of how they would go about determining how to avoid invalidating a statute on constitutional grounds. So can you describe the split, generally the two schools of thought? There's sort of a sub-school in the 11th Circuit, but what are the two predominant schools of thought?
Well, what we have, the line of demarcation, the circuit split, hence, hello, the Supreme Court today, is some circuits are applying a bright line 6-month rule, and that would be the 9th Circuit and the injunction, and the 2nd Circuit. In those circuits, the law of the land is after you have been detained during your removal proceedings for 6 months, you automatically get a bond hearing in front of a judge. You may or may not get out, let's be clear, but you get a bond hearing in front of an independent, objective immigration judge. In the other circuits, the state of the law is that the non-citizen has to establish why they are detained and why and how, what's been going on in that particular case, that detention has become prolonged. And in those circuits, by and large, you have to go in front of a federal district court judge with a federal habeas. And the focus is not, you're not getting a bond, you're not getting release from a federal judge, but you are arguing in front of a judge that detention has become prolonged, and you're essentially arguing that the government is to blame for the delay. And there was a lot of discussion about that today, Michael, as to why a case becomes prolonged, what's the average case, how long people are detained, the government backlog, the lack of immigration judges. It was a fascinating discussion.
Yeah, but the roots of this are in the last time this case was at the Supreme Court, and the fifth vote to uphold the mandatory detention scheme was that fifth vote belonged to Justice Kennedy. And he had speculated that on an as-applied basis, there might be some problems with this prolonged detention scheme, particularly if certain factors were in place, such as the courts were supposed to determine the likelihood of success, but in particularly how long the person had been detained relative to the amount of time that they had perhaps spent in jail previously. But they weren't going to get this relief if the case dragged on because the immigrant was causing their own delay. And how might they do that? They might do that with excessive continuances. They might do that with some, as they said, dilatory conduct. So the court was concerned, this bright line test, if they cross that 6-month mark, well, that might give benefits to some immigrants who didn't deserve that benefit. Why? Because they had slowed down their own cases.
You know, that reminds me. There were a few comments today that personally caused concern in my mind. There are a couple of justices, including the Chief Justice, that seem to think if you file an application for relief like cancellation, or you have a marriage visa petition pending, you're the one causing the delay. There was discussion about filing an appeal. Well, then you're the one who are causing the delay. There was another judge, I think it might have been Justice Alito, although frankly I'm not sure, who said, might have been government counsel, might have been both, you know, you hold the key. Aliens hold the key to their jail cell. If they want to go, they can go. So why are they filing for relief? And that was I didn't like that. I didn't like that conversation. Another thing that concerned me, Michael, was that everybody there in that courtroom seemed to believe that cases are decided, on average 4 to 6 months, and that it's the outlier. And that term came up a lot. It's the outlier case that goes on beyond 6 months. And those of us, like you, like me, like you all, that go to immigration court and go to our country's detention centers know that the average case, the typical average cancellation, waiver, adjustment case in detention goes well beyond 6 months. And those are not the outliers.
And so there's an undercurrent or an understory to this, which was the reasonableness of this whole scheme had been propped up the last time this case got to the Supreme Court. It was propped up by these statistics from the Department of Justice saying that these cases only last a month and a half. If they're appealed, they're only 5 months. So it's not a big deal, this whole scheme, because it's over fairly quickly. Of course, last fall, the Department of Justice sent a letter to the court saying all those statistics, well, they were wrong, and they were off by several times. It was a big factor that they were off of. And something else that the government would want to do here is say, well, let's look at the median time of cases. Why? We all know a lot of cases only have one hearing where the immigrant gives up and goes home. It's the cases where they're working with all of us, where they mount a defense. Every case that's actually litigated are the ones that take the time.
Now, we would be remiss if we didn't talk about 235B and arriving alien, because the majority of the discussion today, most of the clock went to the issue of whether arriving aliens have due process rights, and arriving aliens should be involved in this area of litigation and are entitled to bond hearings. And the attorney for the government, the Solicitor General, took the position several times, point blank, black and white, arriving aliens do not have due process rights. And I want to tell you all what Justice Kagan said about that. She said, well, if they don't have constitutional rights, then can we torture them? Can we force them to be involved in slave labor? Because if they don't have constitutional rights, we can do anything we want with arriving aliens. And I think, there's several issues involved in this case, but I think on this, INA Section 235B arriving alien issue, I think that the immigrant community is going to prevail, and it will be found whether it's 6 months or 9 months or habeas or case by case. I do believe that the arriving alien class is going to be entitled to bond hearings when they have suffered prolonged detention? What do you think?
I think it's hard to predict. I think the ball was moved substantially forward today, though. Justice Breyer framed it really helpfully when he said, well, let's look at these types of cases. The person who is caught at the border can be held without access to a bond, whereas someone who is caught a few days later near the border is entitled to a bond, even though they're essentially the same person. And then when asked point blank if an arriving alien who was detained for 5 years, whether the Constitution applied to them, the government said no. So that's the tension, whether there's going to be some limitation on that or not. The last issue to be concerned about was the court, once there was lots of argument about perhaps the constitutional rights would kick in after 6 months for general prolonged detention. There then became questions about whether 6 months might be an arbitrary date, because the justice said, why not 7? Why not 5? Why not give them a bond hearing immediately? So apparently there's going to be some tension, some pushback about what would be a reasonable remedy. But for the time being,
for now, what do we do for now? File your habeas if you are in that jurisdiction. You need to move forward and file your habeas. And I would recommend, based on the argument today, that you file habeas in prolonged detention cases, even if you have an arriving alien case or a Section 237 case. I'd do both, and I'd keep fighting.
And of course, in the unresolved circuits, the last issue is who should be making these decisions. There's another tension between whether the immigration judges are best positioned for this, whether the habeas courts are the best positioned for this. We all know the inefficiencies of going habeas, but for now, that's the model that we have for most of us and most of our circuits. As always, happy litigating, practice getting into the district courts and using the tools that we have at our disposal.
It's been a good couple of days in Washington. Thank you.